Good morning, everyone, and welcome to this webinar on planning High Court challenges. This is the second in the series, and today we're going to be talking about procedural issues. And we hope that this will be both useful and informative. My name's Neil Cameron. I'm going to chair the session today, and I'm joined by my colleagues, whose photographs you hopefully can see on the screen, James Maurici, who's going to be talking about Aarhus, Andrew Byass, about service and other procedural pitfalls, Joel Semakula, who's talking about planning injunctions, Harriet Wakeman, dealing with general practice and procedure, including duty of candour, right of reply, and Charles Bishop, who's going to talk on the interesting subject of retained EU law to assimilated EU law. So I'm going to start off with a few housekeeping points. Your microphones are automatically muted, so you don't need to adjust your local settings. We really welcome questions, and we will have a answering session after all the speakers have made their presentations. And that hopefully will be well worth staying on the webinar for. Please use the question and answer box to put your questions, and you can enter them at any time during the webinar. If you would like to remain anonymous, please make sure you tick the send anonymously box before submitting your question. And we will try and answer as many questions as we can in the session at the end of the webinar. This webinar is going to be recorded, and you will receive a link to the presentation and the recording shortly after the event. Now, if your connection is lost at any time during the webinar, what I invite you to do is to rejoin by clicking on the original link. So I think those are all the housekeeping matters. So let us begin. Short introductions, which I'm going to do all the introductions now, and then I won't interrupt the flow as we move from one speaker to another. James Maurici will be well known to most of you. He has been in many of the leading cases on Aarhus costs, and he will be speaking about some of them. And those are cases in the domestic courts and before the Aarhus Compliance Committee in Geneva. So I can think of few people better to speak on that subject. Andrew Byass has experience in the past as a solicitor, now as a barrister, and has worked as a public law litigator in the government legal department. So he brings all that experience to bear. He acted in the ETM against Bristol case that he's going to speak about, not, I note, for the late filing claimant. Joel Semakula has a wide-ranging practice, both for local authorities, commercial entities, and he's got significant experience in obtaining injunctions, and he's going to be speaking to us today about planning injunctions. Charles Bishop has experience across the areas of planning, environment, and public law. Ranked as a rising star in planning law by the Legal 500. And as I've already said, he's going to educate us on assimilated EU law. Harriet Wakeman, recognised as a leading junior in the various publications, and she's going to talk to us about recent practice and procedural points, which I'm always grateful for an update on. So that's enough from me, and I'm going to hand over to our first speaker, Charles Bishop.
Thank you, Neil, and good morning, everyone. I'm sure you are all anxiously awaiting this very exciting topic to start your week, probably not able to sleep as if you were trying to get Glastonbury tickets. It is, of course, assimilated EU law. Where are we now? But I thought I'd start with a little bit of a sort of quaint bit of legal history and just go through the timeline to just see where we've come from so that we can then work out where we are now. So I've split this into 4 phases. We'll start with phase 1, which was, of course, when we were a member of the European Union, a much simpler time. If you cast your minds back to the beginning of January 2020, COVID was, I think, then known as the novel coronavirus. Robert Jenrick was the Secretary of State for Levelling Up. Remember that? None of us had even heard of Zoom, which we're now using for this webinar. And of course, the UK was still a member of the European Union. And through that, Section 2, subsection 1 of the European Communities Act 1972, European Union law, or formerly before that, community law, was brought into effect in the UK through the conduit, the Section 2 provision. So phase 2, exit day, defined incredibly precisely as 11 p.m. GMT on the 31st of January 2020 until this phase lasts until the 1 minute to 11 p.m. GMT on the 31st of December 2020. And reason why it's always 11 p.m. is, of course, that in the EU, midnight is an hour ahead in most European countries anyway, certainly in Brussels. During this time, it was essentially the same as when we were a member of the EU. So this was when we were implementing the withdrawal agreement that had been concluded at the beginning of 2020. So EU law was essentially saved under Section 1 of the EU Withdrawal Agreement Act 2020 and Section 1A of the EU Withdrawal Act 2018. The implementation period was completed at 11 p.m. on 31st December 2020. And essentially that phase has continued until the end of last year, when we had what is called retained EU law under the EU Withdrawal Act 2018, and principally 3 sections of that, sections 2, 3, and 4. But at the beginning of this year, we excitingly entered into a new phase of assimilation rather than retention. So the idea was that, and this was under the previous government, the idea was that retained EU law would be assimilated and become part of the legal fabric of the UK and be given, Union Jacks, and all of the laws would pledge allegiance to the King and so forth, and it would become a very British legal framework. So with that timeline and the basic structure set out, I thought I would do another thing that filled us with joy during the 2020 months in COVID, and do a little pop quiz to see how well we all know about assimilated EU law. So the first question is, was legislation made under the old framework, under the 1972 Act, repealed? So regulations, for example, which were made under the powers of the European Communities Act 1972, was that repealed when we left the European Union as part of getting Brexit done? Well, in short, no, it was not. Section 2 of the European Union Withdrawal Act 2018 retains, or assimilates, I suppose we should now say, as EU-derived domestic legislation, which is defined earlier in the Act. So that means that the legislation that we're all familiar with, habitats regulations, EIA regulations, etc., have remained in force despite the repeal of the 1972 Act, because the 2018 Act has allowed these provisions to remain. But some important caveats to that. First one, under Section 8 of the 2018 Act, there was a very powerful power, which allowed the government to make amendments to accommodate withdrawal. So if there were deficiencies in the system that had to be corrected to accommodate withdrawal, for example, references to member states, then those could be made under that power. And that was because otherwise the legislation wouldn't make sense in a non-EU member state, UK. Secondly, and most relevantly and most recently, certain regulations have begun to be sunset from the end of last year under the retained EU Law Revocation and Reform Act 2023. One such regulation is the Habitat Salt Marsh Regulations 1994. Not something I'd come across before, to be honest, but has an environmental colour, I suppose, and it was essentially a way in which aid payments could be made in relation to land that would be dedicated as salt marsh land. The 2023 Act also granted new powers to amend or revoke this legislation. That hasn't been exercised to any significant extent yet, but the idea is that as part of the gradual process of assimilation, the various EU-derived domestic legislation will be amended, replaced, restated in a sort of UK format. During the passage of the 2023 Act, there was a rather ambitious target for all EU-derived domestic legislation to be repealed and replaced by the end of 2023. That project was abandoned, much to the dismay of Jacob Rees-Mogg, whose idea it was. But I think the civil service and wider legal community are probably grateful that that didn't happen. So, are EU regulations part of assimilated EU law? So regulations of the council, etc. Yes, those are part of assimilated EU law. Section 3 of the 2018 Act assimilates all EU, direct EU legislation. So that's not just EU regulations, but also EU decisions or EU tertiary legislation. But those are only assimilated in the format that they had effect in EU law immediately before IP completion day and subject to certain conditions, which are not really important for today's purposes. Also, some direct EU legislation was sunset in the 2023 Act. So getting a little bit harder now, are general principles part of assimilated EU law? No, not anymore. Section 5A4 of the 2018 Act now makes very clear that general principles are not part of assimilated EU law as from the end of last year. Previously, the position around general principles was a little bit complicated. There were various ways in which they were sort of brought into UK law. We had Section 4 of the 2018 Act and Section 6, subsection 7, which retained them as retained general principles, so far as they related to anything which was already being retained under EU law and which were not excluded. The interpretation of this framework was quite complicated. That it was also set out in Part 2 of Schedule 1 of the 2018 Act. The Lipton BA City Flyer case from 2021 in the Court of Appeal goes into this in a bit more detail. It's unlikely to be of much relevance going forward because it doesn't apply to anything after the end of 2023. The Lipton case also went to the Supreme Court, not on this issue, earlier this year, and I'll talk about that a little bit more later in this session. One of the principles of EU law, the principle of supremacy of EU law, has been expressly repealed by Section 3 of the 2023 Act. That's quite important going forward for how the courts will approach conflicts between UK law and EU law, because previously EU law was supreme over UK law, and that was how we had things like factor tame, etc. All of those old cases that I'm sure we can vaguely remember from university about when the EU system would trump the UK. There's also some arguments about situations where there's implementation of the withdrawal agreement and how general principles might apply even after 2023 in relation to that, and see the Court of Appeal decision in AT from around this time last year. I have to say that's quite unlikely to be relevant in any planning or environmental case, but I thought I would include it for completeness. So on a similar vein, is the Charter of Fundamental Rights part of assimilated EU law? No, it is not. Section 5, subsection 4 makes that very clear, and much the same principles apply to this as to general principles. And the AT decision also deals quite extensively with the applicability of the Charter of Fundamental Rights. And I should say, Secretary of State was refused permission to appeal to the Supreme Court in the AT case. So that is the definitive word on the subject for now. Right, moving on to probably the hardest topic in this area, are directives part of assimilated EU law? The answer is no, they are not anymore part of assimilated EU law. Section 2 of the 2023 Act makes that clear. End of 2023, no more directives. Before the end of 2023, Section 4 of the 2018 Act carried forward certain rights. In fact, the full language of the Act was rights, obligations, liabilities, etc., arising under directives which met the condition in Section 4, subsection 2b, which was principally they would be carried forward if they were of a kind recognised by the European Court or any court or tribunal in the United Kingdom in a case decided before IP completion day, which you may remember was at the end of 2020, whether or not as an essential part of the decision in the case. The Harris case looks at that in a bit more detail in the context of the habitats regulation, and it looks at what obligations were recognised or of a kind that were recognised by the European Court or any other court or tribunal in the UK as having essentially direct effect. And Harris case established that certainly Article 6.2 of the EU Habitats Directive did have that kind of effect and therefore could be relied on in domestic proceedings in the UK. However, that is no longer the case because it has been repealed as part of assimilated EU law. But previously, the Maurici duty of interpretation, named after the Maurici case, previously applied, which required EU-derived domestic legislation to be interpreted in accordance with and to give effect to directives applicable under Section 4. And the principle of supremacy would operate with that, so that if a regulation which was intended to implement a directive and the directive had direct effect, then that regulation would not be lawful. However, the principle of supremacy is gone, and there is a new interpretive obligation in relation to domestic law now contained in Section 5, the 2018 Act, which provides that any provision of assimilated direct legislation, so that is such regulations, must be read and given effect in a way which is compatible with domestic enactments. So we now have a principle where then this needs to be in accordance with domestic enactments. I'm not sure that applies to what would have been the habitats regulations, for example, so EU-derived domestic legislation, but it does to direct legislation. I appreciate all these words start to become a bit confusing. So is this the end of directives? So do we need to ever worry about the Habitats Directive ever again in proceedings in the UK? The answer is yes, we do still need to think about this, because there is a sort of general common law principle, which is that if domestic legislation was enacted to implement a directive, then that is part of the statutory context, statutory purpose behind the legislation. And on an orthodox approach to interpretation, then that needs to be taken into account when interpreting what the legislation says. That was established in the C.G. Fry case, which is now going up to the Supreme Court, also concerning habitats regulations. And also in another case in a totally different context called E-Accounting Solutions which recognise this principle. It is not as strong as the mar-leasing duty, and the principle of supremacy doesn't exist. So it's not like the directives could trump the plain wording of the legislation. But it does mean that this is important for how you approach understanding what the regulations mean. And I think also this might apply even in situations where those regulations have been repealed and replaced by something which is of very British origin. So, some new version of the habitats regulations, because if wording in the new version of the regulations carries forward some uses of phrasing, as in the previous legislation, which was intended to implement the Habitats Directive, then there might be some arguments that you could at least advance, and I don't know how a court would approach this, that the directive remains part of the statutory context for interpreting the legislation. So going forward, still might be relevant, and so important to keep that in the back of your mind. So finally, just some other brief things to note, which are perhaps of less direct relevance. First is status of European Court judgments. That is governed by Section 6 of the 2018 Act. That is due to be amended by Section 6 of the retained EU Law Act. And it was essentially nudging the UK courts towards departing from Court of Justice judgments in more instances, and also made provision for references to higher courts by lower courts on these questions, and for law officers of the government to intervene. That was due to commence at the beginning of October, but has been essentially indefinitely delayed while the UK government, the new government reviews it, and there's a regulation that does that. And there's also a case called Industrial Cleaning Equipment, which looks at the status of Court of Justice judgments, if that's something you need to look into at some point. I have to say it's probably rarely likely to be of much relevance in practice, but there will be cases on the extremes where this is important. Similarly, Frankovich claims essentially have been repealed, subject to exceptions. And finally, I mentioned earlier the Lipton case in the Supreme Court. That is essentially about the status of causes of action that accrued in relation to events that occurred prior to Brexit. And it's the first substantive treatment of assimilated EU law by the Supreme Court. It's worth a read if you do need to get into these issues, but it is of kind of dwindling importance because it only relates to pre-Brexit activities. In that case, it was about a flight delay, and the Liptons had been on a flight where a pilot was ill shortly before takeoff, and the flight was then couldn't go ahead, and there wasn't a replacement pilot. And BA City Flyer argued that was an exceptional circumstance within the meaning of the compensation scheme, and so therefore they didn't need to pay the Liptons anything because it wasn't their fault. And the Supreme Court said, no, this is something that happens in the ordinary course of events. You have to expect that pilots will be ill, so you need to accommodate for that. So it was your fault. So yes, you do need to pay compensation to the Liptons. But yes, worth a read if you're coming across these issues. So that's all for me. Hope you did well in the quiz. If not, then you need to go back and look at the Retained EU Law Act again, something that I'm sure we will all enjoy doing. Thank you. Now on to James.
Thank you. So I'm covering Aarhus and updates in relation to Aarhus. I'm just waiting for my screen to catch up. There we are. There's a lot that's happened in the last year, so I'm going to cover recent cases on what is an Aarhus Convention claim. There's been a real spate of those. I'm going to look at some other recent case law on the operation of the rules. I'm going to then look at the impact of the convention on the Wednesbury Standard of Review in one of the best named cases of the year, the Fighting Dirty case. And then look at some other High Court litigation briefly that's involved Aarhus if I have time. And then a quick update on some of the outstanding communications against the UK in Geneva. And then very briefly, the Banner Review and the open call for evidence on Aarhus, which are both currently open for consultation by the government. So just by way of very basic recap on scope, you will know that the Aarhus Convention claim is the key concept which dictates whether you benefit from Aarhus costs protection. And essentially, that requires there to be either a judicial review or review under statute, which challenges the legality of a decisions, act, or omissions that fall within Articles 9, 1, 2, or 3 of the Aarhus Convention. Now, Article 9.1 and 9.2, I'm not really going to be talking about today. I've given a quick reminder of what they are. The focus of all of these cases, and indeed most of the cases, full stop, is about 9.3, which is a kind of catch-all that catches decisions which are said to contravene provisions of national law relating to the environment. So we get into a debate about what is national law relating to the environment. And by way of recap, one of the kind of most important cases of recent times was the Lewis case, which held that in determining if a claim was an Aarhus Convention claim for 9.3 purposes, you have to focus on the nature of the claim. That is to say, the grounds of the claim, rather than the nature of the decision challenged. So it doesn't matter that the decision might be said to be an environmental type decision. It has to be your grounds that are environmental. So that requires consideration of the nature of the provisions of national law, which you are alleging to be breached, because Article 9.3 is only concerned with national law relating to the environment. Now, in order to determine what is national law relating to the environment, you probably need to start with the Court of Appeal in Venn, and they said that environment has to be given a wide meaning, and you should look at the definition in the Aarhus Convention of environmental information. That is a very wide definition, as you can see from just part of the definition that I've quoted at the bottom of the slide. State of elements of the environment, such as air and atmosphere, water, soil, landscape, natural sites, etc., etc. So environment has a wide meaning, but that doesn't mean that it's always easy to determine what is national law relating to the environment. Now, before we get to the recent cases, just finally on the kind of recap, if you have a case under the Planning Acts, it is going to be covered by the Aarhus Convention because planning is environmental law, national environmental law, and I think really then kills that debate. People still seem to want to argue that planning cases are not, but I just don't see there's much room to do that. The other thing by way of recap is the case of Forbes, where interestingly, the court said that registration of land as a town village green, although that carries prohibitions on the use of land and interferes with the use of land, that is not within the Aarhus Convention claim definition. It's not national law relating to the environment. And the reason for that is that recognition as a town or village green, the court said, carries no implication for the state of the land or any modifications to the land or its use. If you wanted to change those, you'd have to go through the process of further consents like planning permission or commons work consents, etc. So the actual act of registering the land isn't actually something that controls the use of the land in that way, so that the Aarhus Convention doesn't apply. So that's where we were before the spate of more recent cases. I would just mention this case, which I found reference to online, where again, similarly, a group of residents were challenging a decision about registration or deregistration of a town and village green. And the developer and the Secretary of State said it's not Aarhus, but the point wasn't decided because a deal was done that the Aarhus cap would apply anyway without prejudice to whether it strictly did. And I'll come back to that issue in a moment. Finally, I suppose just before we jump into the new cases, there's the Friends of the Earth case where Mrs. Justice Thornton held that in relation to a JR of a decision under the Export and Investment Guarantees Act 1991 to provide finance for an overseas fossil fuel project, that this was an Aarhus Convention claim. And essentially, the case was about whether the decision had properly taken into account the Paris Agreement. The argument was, well, that's not national law, it's international law. But the judge said, well, look, the argument is that a material consideration, namely the Paris Agreement, which is environmental, wasn't taken into account. And I consider that to be part of our national environmental law. And I'm going to come back to whether that's right or wrong shortly. So recent cases, four of them that I'm going to talk about. Interestingly, there's been another one since I wrote this talk, a case called White, which is about whether contempt of court proceedings for breach of an injunction in a sort of planning environmental case is covered by the convention, and the court said it was. But I haven't covered that today, but it's worth looking out for. I think it came out last week. So these are the cases, and as we go through them, we need to consider both what the court decided in terms of whether the claim was a convention claim, but also the other routes that the claimants pursued in those cases where it was held not to be, or possibly not to be, a convention claim, in order to try and get protection, even if it wasn't an Aarhus claim. So Wilkinson was a decision by a local planning authority to dispose of land to a football club. The judge, Lange, on the papers said it was an Aarhus Convention claim. She didn't give any reasons, despite this being heavily in dispute. The provisions in issue were Section 122, 123, Local Government Act, and the Greater London Parks and Open Spaces Order 1967, which effectively, as you may well know, deal with the disposal of land, and particularly open space land, by local authorities. Now, the defendant and the interested party argued that the legislation was not environmental legislation, but it was legislation about local government functions, land transactions. And by analogy to Forbes, the Village Green case I mentioned, they said it carries no implication, disposing the land, for for the state of the land or modification of the land or its use, because in due course, the club, having obtained this land, they want to turn it into a training ground for their women's team. They will have to apply for planning permission, and that would be what would be caught by Aarhus. Now, the defendant and the interested party challenged the judge's order. The claimant responded by saying it was an Aarhus Convention claim, but also making a counter application, saying if this is not an Aarhus Convention claim, then the court should, under the 2015 Act, make a cost capping order. Now, the claimant sort of relied on a number of the points that perhaps go to the issue of environmental law and its importance, to say this is a case of public importance that justified a CCO. In the end, the parties reached agreement for a CCO on Aarhus terms, so the point didn't have to be decided by the court. But I think what we're going to see is a trend that even if you successfully manage to argue or partially argue that a claim is not caught by the Aarhus Convention, so it's not an environmental claim, you may well still, if you're dealing with a judicial review or a statutory review, end up having to agree similar terms under the CCO provisions. So the next case on scope is the Client Earth and the Financial Conduct Authority. So this was a judicial review of the FCA's decision to approve the shares prospectus of an interested party oil and gas producer under an EU regulation, and also Section 87A of the Financial Services and Markets Act. And the judge, Lange, same judge as in Wilkinson, and a month apart from the decision in Wilkinson, said it was not a convention claim. Her view was Article 9.3, in referring to provisions of national law relating to the environment, while you could read that broadly, a mere connection with the environment was not going to be sufficient. It must be something more substantial, and she relied on the Court of Appeal's decision in Austin and Miller Argent. And the significance of the claim for the public interest, while relevant, was clearly not decisive in relation to that. And the judge said that the factors that had been relied on by the claimant didn't establish that those provisions that were in issue were matters of national law relating to the environment. She thought that they didn't form part of our environmental law. They were laws about investor protection and the proper functioning of markets. Their subject matter wasn't environmental, nor was their purpose to regulate the environment in any way. Any connection, she thought, to the environment and the purposes of the Aarhus Convention was incidental and remote. And she said that it really wasn't part of the FCA's function when approving a prospectus to evaluate the extent to which a prospectus might promote climate change mitigation or net zero targets. It was all too inconsequentially and too remote to fall within the convention. Then the next case, I think a really interesting one, a really long read, Cotham School, not Mrs. Justice Lang this time, but Paul Matthews KC, sitting as a High Court judge. Now, this was a Part 8 claim by an academy under Section 14 of the Commons Registration Act, that entry on a commons register of some land should be reversed. The question was whether this type of proceedings was an Aarhus Convention claim. Now, a huge number of issues were considered. I mean, slightly bizarre number of issues, frankly, about whether this was an Aarhus Convention claim. The first one, which the judge undoubtedly got right, was to reject an argument that the Academy, for these purposes, was not a member of the public. He said it was acting to vindicate its land ownership in a kind of ordinary way that people would do, and it was not to be seen, the Academy, as part of the state for these purposes, and therefore unable to rely on the convention. That's pretty much, I think, straightforward. The judge then went on to say, well, is this within Article 9(3)? He said, the 65 Act, so far as relevant to this claim, fell, he thought, within the concept of provisions of national law relating to the environment, because Section 14 of the Act concerned the uses to which open land and green spaces could be put and the rights of public to access them. Well, that is, of course, flat contrary to the decision in Forbes, a decision under the very same Act, and which, as far as I can see, wasn't referred to and may well not have been cited. But the judge then went off on a frolic of his own, a point that wasn't argued by anybody, about whether the city council was actually acting as a public authority under the Act, or whether it was acting in a judicial capacity. Quite frankly, that is completely bonkers. And thankfully, as the point wasn't argued, the judge decided he didn't need to determine the point. And I just put note to judge, the fact that no one has ever argued the point, either in this case or any other, might have been a clue that it wasn't really something to pick up on. And then the judge, though, after all of that, still found it was not an Aarhus Convention claim, because if you remember, the definition of Aarhus Convention claim requires there to be a review under statute, either judicial review or a review under statute. And the judge's view that with Section 14 proceedings to correct errors on the register are not reviews under statute. They're not that type of proceeding. So therefore, it was not an Aarhus Convention claim. The judge then had to turn to three other ways in which the claimant was seeking to obtain cost protection. The first was whether they could have a protective cost order under the Corner House common law rules. But the judge said no to that, rightly so, because Venn said if you're outside the Aarhus Convention, as defined by the rules, you shouldn't use the common law PCO rules to get around that. They couldn't rely on a CCO under the 2015 Act, as had happened in Wilkinson, because that only applies to judicial reviews. It doesn't apply to other types of proceedings. And then finally, the court rejected an interesting argument about whether there could still be the imposition of a cap through the rules in CPR Rule 3.19. Now, on the facts, the judge rejected that, felt there wasn't sufficient basis for it. But it's interesting that there is that does provide an interesting further route in other cases to get a cost protection order when you fall outside these. And then I think lastly, in terms of the cases that I'm covering on the recent cases from this year, global feedback and Her Majesty's Treasury, Mrs. Justice Lang again. Now, this was a judicial review in relation to domestic provisions that seek to implement the Australia Free Trade Agreement. And again, the arguments were quite similar to the decision of Mrs. Justice Thornton that we looked at when recapping, because effectively a lot of the argument was about whether the Paris Agreement should have been taken into account as a material consideration, and the judge concluded in the same way Thornton J had in the Friends of the Earth case, that is the domestic law on the environment. If you're arguing that an international convention on the environment was not taken into account, that does constitute an issue of our national law on the environment. And the judge's reasoning was that the UK was a signatory. Those were arguably relevant considerations in public law. The defendants were thus under the obligation in national law to have regard to environmental obligations, or at least arguably so, and that was enough to bring this within the convention. So what are my conclusions on scope in these recent cases? Well, if you're under the Planning Acts, it's going to be within the scope of the Aarhus Convention rules. Stop challenging this, people. If it's a village green or a commons case, who knows what the position is? Conflicting case law. Good luck. If it's an environmental financial type judicial review, one might expect to say it depends on the judge, but even the same judge seems to result in different outcomes. So again, outcome, good luck as to which one that would be. But even if you manage to persuade a court that the claim's outside Aarhus, if it's a JR, then a cost capping order is likely to be an alternative course pursued by the claimant and may well have to be agreed. If it's statutory review or other types of proceedings, you can't apply for a CCO. You probably can't use corner house, and the sort of the CPR cost budgeting route that the judge considered in the Bristol case is probably your only way forward in relation to that. So those are the cases on scope. And there's obviously there was a lot, not so much on other rules. Just briefly, Wesson. This was a claim brought by an individual, W. Wesson, on behalf of Friends of Mill Road Bridge. As you know, you have to produce a schedule of your financial resources to have Aarhus protection. Some information on the finances of the group had been provided, but not of the individual. And the court held that the individual's resources should also have been dealt with. But the failure to do that in making the claim wasn't fatal. You could provide a schedule late, and that's what the court allowed the individual to do. Now, I'm going to touch on this one briefly because I'm absolutely going to run out of time. Really fun name for a case, as I said, Fighting Dirty Limited versus the Environment Agency. Decision of Mr. Justice Fordham, and he addresses a really important question about whether there is a raised standard of Wednesbury review, a sort of higher scrutiny by the courts under Wednesbury of environmental claims. And he rejects the notion that just because a claim is an Aarhus Convention claim and an environmental claim, that means there's a higher test. But he undertakes a really interesting analysis of the fact that obviously the Wednesbury test is something that can be stronger or weaker depending on the type of case. And he explains the kind of things that often occur in environmental law that might well lead a court to take the view that there would need to be a more intense form of scrutiny under Wednesbury. So, for example, the seriousness of an environmental problem and the public necessity of change is something that could justify that higher level. The human rights issues that underlie a lot of environmental law could justify that issue, and there was effectively a variable standard depending on the nature of the claim. I mean, as it was, he actually rejected the need for a particularly intense scrutiny of the decision and the challenge there. But if you are engaged in these issues about standard of review, go and look at the Fighting Dirty case. I'll probably just very briefly mention this. So that Finch, obviously big case of the year, the Aarhus Convention played its own small role, which I won't go into. The Friends of the Earth Cumbria mine case, interesting. There was an application for disclosure of the ministerial submission, relying on Aarhus, amongst other things, which failed. Just an update on communications. There are 4 outstanding communications against the UK, one on the withdrawal bill, one on Wednesbury standard of review, which we just talked about in Fighting Dirty. I mean, that was a communication made in 2017. The hearing was in 2019, still no decision. Shockingly slow at the moment in Geneva. And then there's also a case on free trade agreements, and then also one on planning appeals from Scotland. You can track what's going on by looking at the website that I've given you the reference for. So just 2 other things before I finish. The Banner Review, which, as you may know, was commissioned by the last government, asked to look into ways to effectively curtail the number of challenges that we now seem to have to any DCO that's approved. The current government are consulting on whether to accept these recommendations, effectively calling for evidence. Interestingly, they rule out changing the cost rules because we are members of the Aarhus Convention, but they do propose in the review the possibility that the cap levels could be kept under review and potentially changed going forward in CMCs. I'm not sure about that myself, because I think the virtue of our rules is that it fixes everybody's liabilities early on, and you shouldn't really be changing that unless it's absolutely necessary. There was also some complaints that if you, for example, did something like making it harder to get permission in a DCO challenge case, is that inconsistent with the Aarhus Convention and its obligations? And there's an interesting debate in the report about that. And then finally, there's a call for evidence at the moment open for consultation by the government. What is it about? Well, it's about the fact that there are some cases where the Aarhus Compliance Committee has found the UK to be in breach, and we haven't yet remedied this. So they've come to ask us about three things. One is environmental cost protection, and there's a really long list of things that it's potentially open that we must do to make our cost rules even apparently compliant. I mean, I think many of them go far, far too far, but you know, if you've got a view, express it. There's also one about changing our JR time limits, because we lost a case on that apparently in Geneva, although I have never looked myself at the details of it. I think it was a Northern Ireland case. And then in addition, bizarrely, we apparently lost a case on litter abatement orders. So you can see they're focusing on the big stuff in Geneva, despite the fact that they take 7 or 8 years to reach a decision at the moment. And then that's probably everything. So thank you very much. I'm open to questions. And we're now moving on to Andrew.
Thank you, James. Good morning still, everybody. Again, I'm just waiting to make sure that my slides I've got control of the slides. Takes a moment. My talk is on service and other procedural pitfalls. Over the last decade or so, certainly, we've seen, well, post Denton and White in the Court of Appeal, we've seen a renewed focus on procedural rigour, including in the public law arena. And that rigour has also been applied to the service of judicial review and statutory claims. One moment, please. Can I have the next slide, please? So what I'm going to talk about today is, first of all, that need for procedural rigour, but then how it's been considered in these cases. In terms of the filing and service of judicial review claims, the Good Law Project case in the Court of Appeal really sets the tone for how these things are going to be considered going forward. And my case of ETM contractors is simply really an application of that, and illustrates the strict approach that the court may be expected to take going forward. Notwithstanding, there was some debate in Good Law Project about which approach, there was some difference of opinion, put it that way, about some of the application of the rules in the particular circumstances of that case. And then looking at the filing and service of statutory review claims and the extent to which that may be similar or different to the judicial review proceedings. Can I have the next slide, please? So procedural rigour in the Administrative Court Judicial Review Guide. The Admin Court Guide is really your best friend when it comes to judicial review and practice and procedure. It includes now a statement on procedural rigour, and addresses it in the public law context, and explains that it's also very relevant here. And so even though we are dealing in a public law context with procedural rigour, this doesn't mean that the court will overlook or tolerate breaches of directions made by the court, or of obligations imposed by the CPR or practice directions, or even by the guide. The appellate courts have emphasised the need for procedural rigour and judicial review. And very handily, when you go to this part of the guide, there's several cases in which the courts have emphasised exactly these points. The short point is that so far as possible, including public law claims, you need to ensure that you comply with the rules and court orders so far as possible. There will always be cases where you find yourself in a position where this is not possible, but where that's the case, you really want to try to act preemptively so far as possible. Could I have the next slide, please? So the Good Law Project then, this was a procurement case, but it does underscore the need for procedural rigour, as I've said. The main issue in the Good Law Project case was whether an application for an extension of the time for serving a claim in a judicial review case, which was whether that time should be extended. The application in that matter was made after the time for service had expired, and the question was whether or not CPR 3.12a should apply or CPR 7.6. And as I say on the slide, the answer, of course, is both. It also considered the rules on alternative service under CPR 615. So can I have the next slide, please? So CPR 3.12a will be familiar to many of you. It provides that the court may extend or shorten the time for compliance with any rule, practice, direction, or court order, even if an application for extension is made after the time for compliance has expired. CPR 7.6 applies to Part 7 claims. Part 7 claims are generally a general civil litigation with likely factual disputes, and that distinguishes them from Part 8 claims. And CPR 7.6 provides for the circumstances in which a claimant may apply to extend the time for period for compliance with the rules for service in CPR 7.5. So on the next slide, please, we can see that the terms of CPR 7.6, it deals with where, subparagraph 3 deals with where the application is made after the period for service expires. And the rule here is that an extension of time may be granted only if the court has failed to serve the claim form, or the claimant has taken all reasonable steps to comply with Rule 7.5, but has been unable to do so. And in either case, the claimant has acted promptly in making the application. As can be seen from the facts in the Good Law Project we'll come on to, the all reasonable steps hurdle is a significant one, but a failure to act promptly can also defeat an application. So if we can go to the next slide, Good Law, as I said, decided that CPR 7.6 doesn't apply directly to JR claims, but that its principles are to be followed on an application to extend time for service made under CPR 3.1. In that case, in pre-action correspondence, the government legal department had notified the claimant of the email address for service of new proceedings on the Treasury solicitor. And that's the aptly named New Proceedings email address. But that correspondence also requested that the solicitor within the government legal department also be copied into service of any claim by email. And the claimant in Good Law, having received that notification, served the sealed claim form on time, but to the wrong email address. It was sent only to the GLD solicitor. Also served an unsealed claim form on time to the correct email address, to the New Proceedings email address. And then they served the sealed claim form properly, but that was 1 day late. And proper service came about only because on the day after the service, the time limit for service had expired. The GLD solicitor wrote to the claimant solicitors to point out that there had been defective service. The proper service on the New Proceedings email address was then effected. And shortly after, there was an application by the claimant for an extension of time for service, and alternatively for an order that the service that had been affected be treated as valid service. So there was an application under CPR 3.12 for extension of time, and under CPR 615 that alternative service be accepted. There was also a counter application by the defendant, the Secretary of State, to strike out the claim for want of jurisdiction by reason of late service. And the Court of Appeal ruled that all reasonable steps hadn't been taken. So this is the CPR 7.6 test. And they said at 63, service of a claim form requires the utmost diligence and care to ensure that the relevant procedure rules are properly complied with. And in the circumstances of the Good Law case, they said that what happened there was serious carelessness. It was serious carelessness to provide a copy of the unsealed claim form to the correct address. And even though that served the correct solicitor, the solicitor with the sealed claim form, that still amounted to serious carelessness. And see also at paragraph 57, the court emphasised there's no obligation on a defendant to give any positive assistance to a claimant to properly serve. So the court said there that provided a defendant does nothing to put obstacles in the claimant's way, a potential defendant is under no obligation to give any positive assistance to the claimant to serve. The potential defendant can sit back and await developments. It's no good then, if you're a claimant, to say that a defendant has been opportunistic in taking advantage of your procedural failures. The onus is on you as the claimant to get things done and put them in properly. The next slide, please. So Good Law also considered the service of claims by alternative means under CPR 615. The claimant wanted to rely on its in-time efforts to serve. And CPR 615 provides that on an application, the court may order that the steps already taken to bring the claim form to the attention of the defendant by an alternative method or at an alternative place is good service. The Court of Appeal also rejected the appeal against the refusal to allow service under CPR 615, and that said that while it's critical under 615 that a defendant is aware of the contents of a claim, that can't, without more, constitute a good reason to make an order. The next slide, please. And what they said at 55 of the judgment, following the guidance in a Supreme Court case of Barton, was that in the generality of cases, the main factors in a CPR 615 application are likely to be these. whether the claimant has taken reasonable steps to effect service in accordance with the rules. We can see the overlap with CPR 7.6. Whether the defendant or his solicitor was aware of the contents of the claim form at the time when it expired. This relates to the point made on the previous slide. This is a critical factor, but not a necessary one for a CPR 615 application to succeed. And then finally, what, if any, prejudice the defendant would suffer by the retrospective validation of a non-compliant service of the claim form. So the key difference that we can see between 7.6 and 6.15 is that the latter allows consideration to be given to a broader range of factors, and the court is able to undertake a more balanced assessment focused on what prejudice will actually be suffered by a defendant. But in the good law case, it was sufficient prejudice that allowing the alternative service would deprive the defendant of a limitation defence. The claim was filed at the limitation period, and extending time would deprive the defendant of that benefit, and that was a sufficient prejudice. So that's the context. That's the context within which judicial review claims for extension of time for service will be considered, and they were applied. If we can have the next slide, please. In the ETM case, that's, as I say, a recent example where those specific principles have been applied in the context of planning judicial review, and there were, as I've said on the slide here, a litany of failures, a litany of procedural failures. First of all, the claim was filed late due to the failure to use the court's document upload centre when seeking to file the claim, and on the last day of the 6-week period for bringing a judicial review claim. And remarkably, it took 8 days to resolve that issue. The initial attempt to file had simply sought to email the claim and claim bundle to the court and not use the document upload centre. There were further attempts to email the claim after the initial failure, before the document upload centre was finally used to file the claim, but all of that, as I say, took 8 days. Upon the claim being issued, it was then improperly served by email. First of all, on the counsel at the wrong email address, and then on the developer, who I was acting for, who had specified service was to be accepted only by post. The counsel in this case, like central government, had a central email address for the service of proceedings. That wasn't used. The claim was only emailed to the solicitor who had dealt with the pre-action correspondence. And when the claim was served on the interested party solicitor, the developer solicitor, he was out, and an automatic out-of-office reply was sent. And if the pre-action response letter saying that service should be effected by post wasn't enough, then the out-of-office response should have been, because that had a standard rider on it, which included a statement saying service of any proceedings wouldn't be accepted by email. And then the third failure was that there was defective service on the developer by email in any event, because the email that was sent to the developer failed to include the statement of facts and grounds. The claim form was included, the bundle was included, but the statement of facts and grounds were not. And under the practice direction to CPR 54, the statement of facts and grounds is an essential part, a critical part of a claim form. And in that case, my client taking their cue, and indeed the counsel taking their cue from Good Law Project, waited for these failures to run their course before pointing them out to the claimant and asking them to discontinue their claim. And not unsurprisingly, the claimant declined this invitation and instead made an application to extend the time to file the claim, to extend time for service, or alternatively to allow service to be effected by alternative means, namely the emails that were sent to the solicitors for the counsel and the developer. And those applications were all opposed. On the time for filing, they were opposed due to the prejudice of the developer and the public interest. The development challenged in the ETM case was for 510 new homes, which were to be enabling development for a sports quarter in Bristol. It was expected there'd be some £24 million of cross-subsidised funding that would be released to build that sporting quarter. On the extension of time for service, it was opposed on the basis that applying good law or reasonable steps hadn't been taken. Just as there was serious carelessness in good law, it was said there was serious carelessness here. And then on alternative service, again, the point was made that there was prejudice to the developer and the public interest because the email had failed to include the statement of facts and grounds. So if I could have the next slide, please. So the court's principal finding, perhaps surprisingly, was that it refused to extend time to issue the claim due to the serious error in failing to file the claim form on time, and the prejudice that would result to the developer and the public interest through the delay to the beneficial development granted by the Planning Commission, and also to good administration. I say perhaps surprisingly, because certainly in my experience, the courts in the past have been a bit more willing to look the other way when there's been slight delays in issuing claims. But the 8 days in this case was enough to have this claim effectively struck out. So principally rejected because it was filed at a time. The court had regard to the guidance that was given by the Court of Appeal in the Thornton Hall case. If you recall, that was the case from about 5 years ago, where an extension of time was granted for 5 years to bring a claim. But the facts in that case were really quite extraordinary. But the Thornton Hall case is still represents the latest and best summary of the principles applicable to extensions of time. But in the application of the Thornton Hall case, the court in the ETM case took a strict approach to the need for the claimant to act with the utmost celerity in bringing its claim. The difficulties with filing the claim, the problems that had occurred in seeking to first of all file by email and then through the failure to use the document upload centre, fell at the claimant's door. It was their solicitor's responsibility to ensure that they're aware of the court's requirements for filing and the need to use the document upload centre, and the claimant is fixed with the errors of its chosen representative. The claimant, interestingly, abandoned its application by the time of the hearing to extend time for service, accepting that they couldn't satisfy the requirements of CPR 7.6, which applied, of course, in this case, following good law. It accepted that it hadn't taken all reasonable steps to serve the claim on time. So the next slide, please. Having refused to extend time to file, the court didn't need to decide the application for alternative service. It nonetheless held that it would have refused to permit service by an alternative means under CPR 615, and applying the factors from the Barton and Good Law line of authority. All reasonable steps hadn't been taken. That was the effect of the concession made by the claimant in not pursuing CPR 7.6. The developer was, in this case, was unaware of the contents of the claim because at the time that service was effected, there was the absence of the statement of facts and grounds. And importantly, and I think the fact that the court gave most weight to, the developer and the public interest would both be prejudiced by the extension of time. And that finding in substance overlapped with the finding to refuse to extend time for bringing the claim in the first place. So a really salutary reminder of the importance in judicial review of getting your claims filed on time and then making sure you are aware of and follow the correct rules in relation to service. If I could go to the next slide, please. So turning to statutory reviews then, what then are the similarities and differences? Well, unlike in judicial review, where there is a discretion to extend time for service, the time limit to issue statutory review proceedings is absolute. And that was reiterated by Lord Justice Lindbaum in the Croak case. And in Section 288 challenges, for example, the application for leave must be made before the end of the period of 6 weeks, beginning with the day after the relevant date of the decision letter, or in another case, or in other examples, for example, the date the relevant order takes effect. And in Croak, the court confirmed that the statutory time limit was absolute, even when the applicant himself may not be entirely responsible for the late filing of the application. And that was the gist of the arguments being made in Croak, that there were circumstances beyond the applicant's control, which meant that he couldn't comply with the 6 week time limit in that case. And the court rejected that and reaffirmed the absolute limit of the 6 week period applicable to statutory reviews. So the next slide, please. So Farnham Town Council is interesting because it's a recent case looking at the circumstances in which the time period for service can be extended. That involved a 288 challenge against the planning inspector's decision to grant planning permission for 156 homes. The proceedings were issued in time, but served 4 days late due to the town council's legal department's misreading of the rules. They thought they had 7 days to serve, just like they do in JR. That, of course, is wrong. Statutory reviews must be served within the same 6 week period as applies to issuing a claim. So that's a key point of difference and something to be very aware of. Stating the obvious, don't file on the last day, lest you run the gauntlet of also having to serve on the last day. So if we go to the next slide, please. So the key issues in Farnham then were, first of all, whether the court had the power to extend time for service. If it did, whether it should extend time, and then finally, if it extended time, whether it should uphold the challenge. And the court considered all of those issues in its judgment. I'm only going to look at the first two. And on the first key issue, the claimant sought to argue that good law, the principles in CPR 7.6 shouldn't apply to the exercise of the court's discretion under CPR 3.12a. The claimant argued that the Court of Appeal's decision in Chorus from 2006 was binding authority to the contrary. Now, Chorus had been considered in previous decisions in the High Court, which dealt with statutory review challenges, but the claimant in Farnham argued that those cases had been wrongly decided and that Chorus was binding on the High Court. So if we go to the next slide, please. So Chorus was directly concerned with a statutory review challenge, and so not judicial review. And the Court of Appeal in that case had expressly rejected the submission that it should apply CPR 7.6 to the application for extension of time for service in that case. And it said that instead, applications for extension of time should be considered under the general rule in CPR 3.12a, which you'll recall is the general power provided to the court to extend or shorten the time for compliance with any rule, practice, direction, or court order. And on that basis, such an application is considered by reference to the now normal or familiar Denton and White principles and not the stricter test in CPR 7.6. And so if that's right and CPR 7.6 doesn't apply, the considerations would be, in a statutory review challenge at least, how serious and significant the breach is, why the breach occurred, and then finally, a consideration of whether relief is appropriate and just having regard to all the circumstances of the case. So it's a more holistic assessment that is able to be taken under the Denton and White principles compared to CPR 7.6. And the claimant forcefully argued that the Section 288 authorities that applied good law were wrongly decided, since Chorus was directly concerned with statutory reviews and good law was about judicial review proceedings. But the court rejected those arguments and applied good law. It relied on changes to the CPR, but it also found that good law is not wholly at odds with Chorus. It effectively reconciled the two decisions and said that good law takes matters further. What Chorus decided, in the court's view in Farnham, was that CPR 7.6 didn't directly apply, all well and good. But what good law decided was that CPR 7.6 applied by analogy, which was a point not expressly considered in Chorus. And so through this reasoning, the court was satisfied that the good law approach did apply, and that it had to apply the same strict tests, as you can see in that. So if we can go to the next slide, please. So we see then that the overall result in Farnham was the court rejected the submission that the absolute 6-week time limit for filing a service in statutory reviews justifies a different approach to judicial review. And part of the argument, this argument was rejected, despite the fact that in judicial review there is the opportunity to seek further time to issue proceedings, and despite the fact that there are examples such as the Thornton Hall case, where an extension of time can be allowed for a very significant time period indeed. But the court said in relation to this argument that while there are still some differences between the approaches in statutory review and judicial review, the direction of travel is definitely about bringing the two procedures closer together. And the strict application of the civil procedure rules in ETM rather bears this out. The claim in that case wasn't particularly late, and there's also the competing public interest of having a properly decided planning application, which would determine the future relationship between ETM, which was a waste operator, and future residential dwellings and residents of those dwellings, which would be located near to what would be a potentially very noisy source of, and quite a high noise source very close to their dwellings. Yet the court still refused to extend time in that matter. The court also adopted and relied on the statements in Croak, emphasising the importance of certainty and consistency in statutory review challenges, and I've given you the references there. So what then about the alternative arguments? So if we go to the next slide, the court also considered, well, if I could extend time, if the court could extend time, should it? And it said it wasn't prepared to do so for these reasons. And for these reasons, it effectively precluded an appeal. There's no point this claimant appealing when the court found against it on the facts as well. But I think the Chorus point is potentially available still to future claimants if they wanted to take it. Probably not in the High Court, given the run of authorities that have decided that chorus can be distinguished, but it is a point potentially available in the Court of Appeal. And also, as a watch this space point, is the fact that the good law judgment was also granted permission to appeal by the Supreme Court in January 2023. I don't have any information on the grounds of why the appeal hasn't yet been heard. It's certainly been a long delay, but there may be circumstances in which both of these authorities could be reconsidered by the courts going forward. Certainly for now, though, the trend is to a very strict approach to procedural rigour, and a warning to everybody involved in these sorts of claims to be very cautious about the way in which the procedural rules are approached, and ensuring so far as possible that you do make sure that you meet them and comply with those time limits. I'm very happy now to hand over to Joel, who's going to be speaking about planning injunctions.
Thank you, Andrew. It's going to take me a moment also just to get control. I'm sure my moment will arrive shortly. Okay, there we are, we have it. So there on the slide, you'll see the topics I'm going to address. Now, we've had planning injunction cases at all levels of the courts in the last year. In the time I have, I'll attempt to draw the key points out of those who, for those who practice in this area. And ending with God, but we'll see what we have to say about that. So we'll start with precautionary injunctions against persons unknown. This judgment is one of the most talked about judgments in, which came out late last year. And of course, whenever we're dealing with injunctions in the High Court, we start with the well-known Section 37 of the Senior Courts Act 1981, which confirms and restates the power of the High Court to grant an injunction in all cases in which it appears to the court to be just and convenient to do so. Now, the approach to be taken when an injunction against persons unknown is directed at or will have an impact on the activities of members of the travellers and gypsies communities is that laid down in Wolverhampton and London Gypsies and Travellers, a case handed down by the Supreme Court last November. The case has much to say about the origination of proceedings against defendants in this context. It explains that there are three categories. First, if the names of the person said to be committing the prohibited or potentially prohibited acts or who are to be subject to the injunction are known, then those persons should be named and joined as defendants. Second, where the person committing such acts or to be enjoined exists, but their names are not known, then if it's possible to identify them by description, they should be so identified and served. However, the third category is such that when relief is sought against persons who do not fall into either of those two categories, then it's only in those circumstances an injunction should be sought against persons unknown. For example, the animal on the screen, is it a wolf? Is it not? Is it a wolf? Unknown. I'll leave that for you. If we look at Section 178B3 of the 1990 Act, it provides that the rules of the court may provide for a planning injunction to be issued against a person whose identity is unknown, and we'll come back to that. But what the Supreme Court effectively did in Wolverhampton emphasised the starting point is that a local authority seeking such an injunction must establish that there is a compelling justification for the order sought. That will require the authority to show that there is a strong probability that a tort or breach of planning control or other aspect of public law is to be committed, and that this will cause real harm. Further, the threat must be real and imminent. Sticking with this theme of precautionary injunctions against persons unknown, the Supreme Court also said the authority must show the need to protect the relevant rights or to prevent the anticipated harm cannot be adequately met by any other measures available to the authority. And so although the Wolverhampton case is actually just about gypsies and travellers, this judgment is of great importance to anyone who works in the injunction world, and it's now cited every time a party seeking to secure an injunction against persons unknown. For example, in the environmental protest context, which is another area that has taken up much of my time really over the last 12 months. So Within the judgment, the application of the principles which the Supreme Court identified was explained at paragraphs 187 to 234 and summarized at paragraph 238. The key point is that the test to be applied when granting a final injunction in the context of gypsies and travellers and protests against persons unknown, including newcomers, it's not actually materially altered by this particular decision. The factors identified by the Supreme Court are materially the same as those developed in Canada Goose at paragraph 82. So it's being clear that Canada Goose there remains good law. And it should be noted that the case was about restraining animal rights protests, that being the Canada Goose case. Indeed, there on the slide, you can see Canadian goose mid-flight. On a practical note, if you're acting in a case where a party is seeking an injunction against persons unknown, it's probably easier to go to the judgment of Mr. Justice Ritchie and Valero, there at paragraph 58, where he conveniently sets out the Canada Goose and Supreme Court's Wolverhampton's additional factors in a list, which is quite easy for practitioners to follow. And a final slide here on the Wolverhampton case. I'm not going to take you through that full list that Mr. Justice Ritchie sets out, but I do want to highlight some final key points from this case. The first is the context of these injunctions. The Supreme Court here said that there's unlikely to be a real dispute for resolution in these types of cases. And what we're talking about there is it's just rare that we'll get a trial as well as when you're pursuing or seeking injunctions really against persons unknown, either in the gypsy traveller context or even in the environmental protest context. And also, although Wolverhampton was an interim injunction case, the Supreme Court has now made it clear that there's no relevant jurisdictional difference between interim and final injunctions. Next, the court expects claimants to provide full and frank disclosure when seeking injunctions against persons unknown, those persons obviously not being in court. And third, the orders must have clear geographic and temporal limits. Fourth, the claimant must provide evidence of compliance with the requirement to advertise the application in advance and give effective notice. And I'll come to the case about service in the context of injunctions shortly. And finally, these orders must provide for their periodic review, something, again, I'm going to come back to. In most of the orders that we're seeing at the moment, we're usually seeing those reviews being scheduled for about a year, so annually. Next, I want to talk about the review of injunctions. This is a High Court case, Basingstoke and Dean, Borough Council and Loveridge, a judgment of Mr. Justice Friedman. It's another gypsy traveller case. And here, on reviewing the injunction, the High Court determined that claimant local authorities had demonstrated a compelling need for a 1-year extension of a 5-year injunction against 116 persons unknown, preventing unauthorised encampments and the depositing of controlled waste in breach of planning control. Mr. Justice Freeman said there was a danger that the reaction to Wolverhampton was that these cases, particularly on review, simply became a box-ticking exercise, that they were simply reviewed every year and the injunction was then continued. In his view, that would fail to reflect the guidance that the remedy was only to be granted, that being the remedy against persons unknown, where there was a compelling need for protection. And going forward, a careful evaluation will be required in this particular case in respect of matters such as the absence of a negotiated stopping policy, and the court would scrutinise the steps that the local authority had taken to actually procure that policy. So it's really there a word of warning for local authorities, that stopping policy, of course, being in respect of gypsy traveller sites. And I'm expecting there's going to be some debate around the intensity of review on these persons unknown cases. So again, not only in this gypsy traveller context, but particularly in the protest context, where late next year we're going to see a number of these reviews come in before the High Court again. The next case I want to talk about is Pembrokeshire County Council and Cole. In this case, the judge determined it was not appropriate to exercise his discretion to grant a mandatory injunction under 187B of the 1990 Act, requiring 2 individuals to remedy unauthorized development they had carried out on farmland. Now, in refusing to grant that injunction, the court considered a number of common arguments that come before the High Court when a party seeks one of these types of injunctions. The first point was that this was not a case. This case did not involve flagrant disregard for planning control, insofar as the defendants had made genuine efforts to regularize the position and to obtain the necessary permission. The judge held that some weight had to be placed on the fact that the local authority, as a democratically elected with responsibility for the relevant area, had exercised its discretion to apply for an injunction. The lack of evidence here that the local authority had weighed the defendant's personal circumstances in the balance, however, did not count significantly against granting relief. And unsurprisingly, the fact that the defendants had made sacrifices of time, effort, and personal commitment in respect to the development did not provide any good reason for declining to grant an injunction that would otherwise be justified. Here, the court gave limited weight to the defendant's assertion that removing the offending shed in this case would have severe financial consequences for them, and in fact, there was insufficient evidence before the court of the same. But although there was some evidence, and also this argument, one that you hear quite often, that the local authority's handling of the matter over the years was irrelevant. If, as was alleged in that case, there had been failures of communication on the part of the local authority that had caused frustration or anxiety for the defendants, that was no reason not to grant any injunction that would otherwise be appropriately granted. The context here in this case is particularly important. While the defendants undoubtedly remained in breach of planning control and of the terms of the enforcement notice, they had genuinely sought to address the planning objections to their development, and they had a pending planning application that could not be regarded as having no real prospect of success. So an injunction will probably cause them serious financial harm, and the evidence did not demonstrate either that the current situation was causing or likely to cause environmental harm, or that the local authority believed that to be the case. And that was a really key point. The local authority itself didn't consider here that the breach was leading to that environmental harm. And so the court determined that an injunction was not required urgently. Hence here, we got no final injunction. Probably very frustrated local authority. Moving on to costs. About Londonborough Council and Shiva Limited. Now, this is interesting. This was an application by the defendant company seeking an order the claimant council pay its costs. Here again, the underlying claim was for the well-known 187B injunction. The development being enforced against was an art installation. Two relevant points to start with. The first, that a number of interim injunctions were indeed granted in this case, and the defendant had refused to provide an undertaking at the inter-parties stage. Now, the claimant's case on this application was that an injunction was required and appropriate. The first defendant's case, the defendant company's case here, was that the council's position was unjustified and the claim had been unreasonably pursued and should be discontinued. It argued that effectively it was a successful party. This is because the enforcement of the planning control had been overtaken by the fact that planning permission had been granted to the defendant, and cost orders should follow the event. The point being that the claimant simply could not win or obtain the final relief that it sought in its claim because now the defendant had planning permission. The claimant's case was that the matter still needed disposal, it arguing that it did not bring its application to try to prevent the development, but to prevent the installation being erected without planning permission. Now, on the question of costs here, the court held the fact that the first defendant did, in January 2024, obtain planning permission does not mean that the claimant was unsuccessful in making its claim under Section 187. To the contrary, it shows that it had correctly acted to stop an apprehended or actual breach of planning control. So here, the court held that the local planning authority was correct. Planning permission was needed, and in fact, it was granted, but with conditions. And here, the defendant company had proceeded at its peril in simply erecting the installations without talking to the council. And once the injunction was granted, the defendant company here could have undertaken to wait until planning permission before erecting the installation, but it did not. And the local authority here was awarded its costs, however, only partially, because the judge here held that a without notice injunction is a matter of last resort. And in this case, he only allowed the cost of the inter-parties application. What about the relevance then of extant planning permission appeals where you're dealing with a committal? So you've got the breach has been established and we're at the point where we need to determine what to do with the defendant. The case here is South Oxfordshire and Probitz. Here, the High Court made it clear that an outstanding planning permission appeal in relation to land is not directly relevant to committal proceedings against the defendant accused of allegedly breaching a Section 187B injunction in respect of the same land. Let's compare that, remember, to the position I mentioned in Pembrokeshire, where it was held that the existence of a pending planning application that could not be regarded as having no real prospect of success was a relevant factor in declining to exercise the court's discretion to grant the injunction. Here, I've included the prison meme simply because it made me smile, because my own cat regularly does things for which she should probably be put in cat jail, but of course I would never. And at the bottom there is a picture of that cat, which none of you asked for, but like any new parent, I thought I'd share. Service. I just want to talk quickly about Basildon District Council and Con Healy, the judgment of Mrs. Justice May. And now we all understand the importance of service to injunctions, and CPR 6.15 deals with service by alternative means. Here, service by an alternative method was permitted where the defendants had tried to avoid service and had continued breaching planning controls. It was held that affixing an injunction, claim form, and relevant documents to 8 stakes in the ground on parcels of land was deemed effective service, as were phone calls to 2 of the defendants and by inference the other 3 defendants to advise them of the injunction and to seek their postal and email addresses. And again, back to the protest world or the gypsy traveler world, alternative service is something that regularly comes up. And when you come before the court, you need to provide sufficient evidence that you've attempted or to serve by normal means, and if not possible, that the alternative methods that you are seeking to serve by would be effective to bring the injunction to the attention of those who need to be aware of it. Ending with a case that really just made me smile. This is Adam and Cheshire East Council. It's a judgment of the Court of Appeal following an appellant's appeal against a 12-month suspended sentence imposed on him in relation to his failure to comply with a planning injunction obtained by the claimant counsellor here, Cheshire. The appellant argued that he was not a person under the Town and Country Planning Act 1990. That was unsurprisingly rejected by the Court of Appeal. Although, as I've already mentioned, the only reference to a person in Section 187B of the 1990 Act, under which the injunction had been made, was to a person whose identity was unknown. And the court held, even if the injunction had been made against the person, his argument was unsustainable. The court simply relied on the definition of person in Schedule 1 of the Interpretation Act 1978, which included bodies corporate and unincorporated, extending the ordinary meaning of a person and did not narrow it to exclude human beings. So no surprise there. They also held that common sense made it abundantly clear here that he was a person for the purpose of the Act. I should add, he appeared in person, and that argument was not advanced by counsel. Further, his argument that the land was God's land did not advance his case any further. An injunction had been made against him to do specified things, which he'd failed to do. The property was registered in the land registry in the appellant's name, and the official copy of the Towel Register named him as the registered proprietor of the land with which the appeal was concerned. He was accordingly its owner. On a practical note, the original injunction had not included the red delineation, which the Court of Appeal considered was unfortunate. Nonetheless, it held the judge had been entitled to conclude that the appellant had always been aware of the injunction's impact and had chosen to defy it. You're probably wondering then, how did this end up at the Court of Appeal? It should be noted that an order for committal does not require permission to appeal. And here the appellant sought to challenge not only the sentence, but also the finding of breach. The image there on your slide is, of course, God's land, according to Google. And with that, I'd now like to pass on to Harriet.
Thanks very much, Joel. I'm just going to wait to take control of the slides. Thank you. Good afternoon, everyone, and well done, I suppose, for sticking with us until this point. Mine is the last talk of the session. And I'm going to be doing a general practice and procedure update, which is largely going to focus on the duty of candour. And in terms of topics I'm going to be covering, it will be mostly, as I say, the duty of candour, and obviously that overlaps to a degree with disclosure issues. Then some recent case law on extensions of time in Section 289 challenges, and then very lastly, very briefly touching on the new right to reply. So kicking off with duty of candour. So this is, of course, the duty to assist the court with a full and accurate explanation of all the facts relevant to the issues which the court must decide. It's important to note at the start that the duty of candour is information-based, so it's not restricted to documents, although in some cases it may require the disclosure of documents. And as we'll see from the case law, the line between the duty of candour and disclosure can overlap very substantially. Of course, the failure to properly discharge the duty of candour can have very serious consequences, including obviously reputational damage, but also adverse inferences, cost orders, or at the extreme, contempt of court. So I'm first going to have a look at duty of candour in the JR context, and then I'm going to turn to the planning statutory review context. So the first case to touch upon is the recent decision of Mr. Justice Fordham in the Police Superintendents Association. That was a judicial review, not in the planning sphere, but challenging instead a recommendation of a flat rate pay increase to all police officers at all pay points for all ranks, and the Home Secretary's decision to accept that recommendation. And the association brought the proceedings and argued that the review body and also the Secretary of State had essentially breached their public sector duty. Crucially for our purposes, it's important to note that the Secretary of State's summary ground of defence stated that she'd accepted the recommendation after considering 2 ministerial submissions. And the grounds then quoted from the submissions, but they didn't actually disclose the submissions themselves alongside. And so an application was made for permission stage specific disclosure. And in answer to that application, the Secretary of State argued that the duty of candour did not require disclosure of the ministerial submission, because they said that they provided the substance of that information in the documents. And Mr. Justice Fordham identified 10 key principles, which he said were important to this issue relating to specific disclosure and the duty of candour. I'm not going to read them all out, but just to whiz through them very briefly. We've got standard disclosure. General parties are not required to give standard disclosure in judicial review. I think that's fairly uncontroversial. Just disposal principle. That's the test for ordering disclosure of specific documents is necessity to resolve the matter fairly and justly. And that's the language of the test in Tweed, which is the leading case really in this area on specific disclosure. Candid disclosure, cards face up. The information to principle, relevant facts be identified in witness statement evidence insofar as unapparent from contemporaneous documents. Relevant material principle, that's set out there. I'm not going to read that one out in detail. Then there's the non-selectivity principle. Disclosure must not be selective, must include the unhelpful as well as the helpful. I don't think that's controversial. Just going to pause slightly on the best, what Fordham J describes as the best evidence principle, which is that documents should be produced, not gisted, or a secondary account given. That's controversial, and I'm just going to come back to that later. Redaction principle, permission stage principle, which is that the duty of candour applies prior to and for the decision to grant permission, and the unpleaded grounds principle, which is that the duty extends to documents and information which will assist the claimant's case or may give rise to further grounds which might not otherwise occur to the claimant. So that was the kind of 10 key principles which were set out, and the judge decided that the Secretary of State's legal representatives had, in this case, apparently misrepresented the law, albeit entirely in good faith in doing so. And he said at paragraph 17, "It is in my judgment wrong to conclude that it is or has become sufficient for public authority defendants in judicial review cases to communicate, whether in witness statements or grounds of defence, the substance of undisclosed primary documents, such as ministerial submissions, as an alternative to producing or exhibiting the primary documents themselves." Although interestingly, on the facts of that case, he then held that because the relevant part of the submissions, the ministerial submissions, had been set out in the summary grounds, and an assurance was given from counsel that there was nothing in the undisclosed materials that would assist the claim or give rise to any further grounds of review, then the in that case they didn't actually have to disclose. So it sits somewhat oddly there. So whilst I think the 10 principles are essentially a useful summary of the current law in the judicial review space specifically, there are problems with and limitations to the decision. I think firstly, it's unclear when it is necessary to disclose primary documents prior to the grant of permission, because we have no guidance on that. There's some controversy about the accuracy of what was called the best evidence rule. It's more absolute than the way it's framed in the leading case of Tweed. It's not clear in every instance precisely what the principles entail. So principle 5, that has 3 sub-principles, but only one of them actually seems to be related to disclosure. And then I think what's most interesting is that if you look on Westlaw as to where this case has actually been applied, although it seems to be kind of embarking on this new era for the duty of candour and specific disclosure, it's not really had much uptake since the judgment was handed down in terms of other judges. And interestingly, I was at a conference earlier this year where Mr. Justice Swift chaired a panel and this case came up. And I think, to put it nicely, he was not very enthusiastic about it. And so when I was preparing for this talk, I thought, well, I'll just check if anything's happened. And lo and behold, Mr. Justice Swift has handed down a decision in the case of Coulthard quite recently, where he's clearly got his hands on the police superintendent's judgment and made very clear that this is 10 situations where an application for specific disclosure might succeed. He said they're not principles, they're not any form of codification of the law and disclosure or the duty of candour, and instead they're just merely examples of the application of the principles stated in Tweed. So it seems as though there's already quite a bit of kind of distancing happening from that decision. So that's the position and the latest case law in the judicial review context. I'm now going to turn specifically to look at the planning specific context. And that, of course, is in the recent Cumbria coal mine case. And the key question here was whether specific disclosure of ministerial submissions was appropriate in a Section 288 appeal. So interestingly, also about ministerial submissions. Short answer was no, it wasn't necessary. In that case, the disclosure of the submission could not assist the claimant either in relation to the grounds of challenge, nor was it necessary for the fair disposal of the claim. And longer answer, so I've just put here paragraph 5 of the judgment, set it out in full because I think it's just a really helpful point, which is the starting point is that disclosure provisions of CPR 31 play a limited role in conventional judicial reviews only anyway, but they've been explicitly disapplied in the statutory planning review context by 54D. There's no statutory provision for the disclosure of any ministerial submission, despite their commonplace use. There's no general procedural rule or any guidance in the practice direction to support its disclosure. Rather, there's a specific exclusion of disclosure in statutory review. And the CPR and practice direction set out no principles as to when such disclosure should be ordered. then, I've not included it on the slides, but if anyone has time to kind of look into this further, paragraph 7 is a really helpful explanation of essentially what the duty of candour is in this planning statutory review context and the relationship between specific disclosure and this duty of candour. And it's noted there that it's a related but separate duty of candour. And it doesn't necessarily require any particular level of disclosure of documents, save perhaps where a purportedly accurate summary of a document is furnished instead of the document itself. So I think that's the key point. It's a related but separate duty to specific disclosure. And then I've set out on the slide paragraph 8 of the judgment, which is interesting, where it was said that the Secretary of State's defence in the form of the statutory challenge stands or falls by what the decision letter says and by the reasons it gives for the conclusions reached. Where the Secretary of State adopts the reasoning and conclusions of the inspector's report, as he did here almost entirely, the reasoning of the Secretary of State is also found to be in the reasoning of the inspector's report. So it is not open to the Secretary of State to defend the decision when challenged by supplementary decision letters or witness statements saying that was a factor in fact considered in response to a contention it was overlooked, or by elaborating or explaining reasoning. And it would be very undesirable were that to become a permissible form of defence, with hindsight enabling wisdom and judgment after the event. And the judge then went on to question, in this particular circumstance, the relevance of the ministerial submission, and essentially identified the fact that it was pretty much a lose-lose situation. It wasn't really going to take anyone any further, and that's paragraph 10. And then there was noted paragraph 11 that there was a real risk with the unnecessary deployment of ministerial submissions on a routine basis, and that it would lead to essentially an irrelevant and costly collateral debate about what the ministerial submissions meant. So it was very clear there's no blanket ban on getting disclosure of ministerial submissions, but such an application must be based on the facts and issues in the case in question. The touchstone for specific disclosure will be the test in Tweed. That test, apparently, it was said in that case, will rarely be satisfied, and a cautious approach is needed. And then in that case, on the facts, the specific disclosure application was dismissed. So headline takeaways from that case for other cases, there wasn't any specific disclosure on that facts. I think the door has been left open for successful specific disclosure application of a ministerial submission in another case, but probably only slightly. And I think it's going to take a specific set of facts, and the Tweed case will be the test to apply. And I've just put as a final bullet point to note, it's obvious, but this is relating to planning statutory reviews only, not judicial review more generally. So that was a very whistle-stop tour over the most recent case law in duty of candour and specific disclosure. I'm now just going to turn to highlight two key and quite contrasting ways in which the court has dealt with applications for extension of time in section 289 challenges. This is the case of Epic Capital and Waterhouse. Epic Capital, this concerned an application for permission to appeal an enforcement notice. The deadline for making the application in that case is 28 days after the notice of the decision is given, and that's CPR 54D paragraph 6. So on the facts of that case, they had until the 20th of October 2023. And I think it's fair to say there was a pretty woeful procedural history that then played out, which involved the wrong and incomplete documents being filed. Appellant's notice wasn't filed until the 14th of December. Bear in mind that the original deadline was meant to be 20th of October for making the application. When it was filed, there were missing documents, and the court listed a hearing in early January. At that point, there was still no grounds of appeal or witness statements, and service hadn't taken place. And it eventually got to the point where there was a preliminary hearing 88 days post-deadline, and these issues were still outstanding. And the court applied the Denton criteria and noted that the explanation for the issues essentially was just that the applicant's solicitors were overwhelmed, and there had been a serious and significant delay 88 days past the deadline and essential procedural steps had not been taken. So that wasn't viewed in a very sympathetic light by the court, perhaps pretty understandably in the circumstances, and that application to extend time was refused. Just want to contrast that case with the decision in Waterhouse. This was another application for permission to appeal under Section 289. The way that that case found out, nothing in the end actually turned on the delay points, but the court kind of quite helpfully set out what it would have said had that part been operative. And the court noted that the Denton criteria applied. In that case, the planning inspectorate had actually referred the appellants to contact the administrative court if they wanted to bring a challenge. And then this will be unsurprising to anyone who's tried recently to get in touch with the court, but the appellants then had difficulty getting through to get hard copy forms to bring their appeal. They produced evidence of the phone calls and emails that they had trying to get through to the court. And then they accidentally sent the wrong forms, which were returned by the court. In the meantime, they also emailed the court. What the court said was essentially a skeleton. It was essentially an appeal document, even though it described itself as being a skeleton case. It set out the decision under challenged, and it outlined the basis for impugning the inspector's decision. All in all, the correct forms were eventually filed, and they were lodged about 18 days outside of the 28-day time period. And what was said by the judge was, had I found a viable ground of appeal, I would then have extended time in the overall interest of justice. That would have been in light of the viability of the appeal and because of a combination of, one, the messaging from the Secretary of State's Inspectorate, two, the frustrating quest via phone calls and emails for documents from the admin court, which, and three, the attempted filing of the skeleton. I would not have otherwise shut out an otherwise viable appeal. So it seems that key factors there were viability of the appeal and the fact that it was essentially a well-intentioned failure to comply, and that they could evidence that the quite significant steps and efforts taken to attempt to comply. I don't think, to be honest, either of those decisions are particularly surprising. In my experience, courts are usually more sympathetic to well-intentioned but mistaken appellants who have tried to comply but failed to do so, particularly people that are not legally represented, and equally, courts likely not to be particularly sympathetic to solicitors just failing to comply because they're overwhelmed with the amount of caseload. And just to finish off, I'm not going to spend much time on this, but it was just to flag that there's the new right to reply in CPR 54.8a. This was a change brought in to permit claimants to file a reply to an acknowledgement of service. Essentially, you have not more than 7 days after service to do it. You need to serve it on the defendant and any other person served with the claim form, and as soon as practicable, and in any event not later than 7 days after it's filed. And finally, we see from Practice Direction 54D that this does have an application in the planning statutory review context. And there's some key points there. But basically, you need to ensure you're only filing, if necessary, for the purpose of the court's decision to grant permission to apply for judicial review. And that would be, for example, if there's a new issue which needs to be addressed. It's not a opportunity to just simply rehearse matters that have already been referred to. And if you do, you might face costs. So be a bit careful with that one. And that brings me to the end of my slides. I think there's been potentially some questions coming in, so I'm going to hand back over to Neil. Thank you.
Well, thank you very much to all our speakers. It takes a lot of time to prepare those talks, so we're extremely grateful to them. And I think their talks have been so clear that there are no questions that have appeared in the question and answer box. I hope that's because of clarity and not because of some issue with that function. Anyway, I have one or two questions of my own, so I'm going to try some of those in the remaining few minutes we have. James, can I start with you on the Aarhus Convention points? And the question is this: what are the limits to an argument based on Article 9.3 when in global feedback the court appears to have taken a fairly wide view of environmental obligations? So what are the limits to an Article 9.3 argument?
Yeah, I mean, I think I think there's a kind of a disconnect between some of the cases at the moment, because some of them, like Forbes and probably like Lewis, are focused on the legislation that's in issue and that it's being raised, and whether that legislation constitutes national environmental law. And I mean, that's all fine, and one can have an argument about whether village green legislation meets that or not. I mean, I find Forbes quite persuasive on that if you're just looking at legislation. The problem is, once you veer over away from that to look at the fact that the grounds are alleging something like you failed to take into account the Paris Agreement or an international treaty about the environment, on one level, that's not environmental law, it's just our ordinary administrative law. But if you say, the moment that you raise failure to consider something environmental, that is part of our national environmental law, then that's going to bring vast amounts of litigation into the Aarhus Convention protection. So I think there's a disconnect between looking at how this works for legislation, which is perhaps easier, and how it works for common law grounds of challenge. But I mean, I agree with you. I think the expansive approach that's taken in some of those cases, I think, means that it might be quite, it might be increasingly tricky to say that that a claim falls outside 9.3. And then, of course, even if you do, you've still got to deal with all the other routes like CCO, etc. So, I mean, these days it's often better just to agree cap and move on with the litigation than get involved in the fight, which, on a personal level, I find quite disappointing, but is probably the right thing.
Thank you, James. Yes, I think in some cases it's better just to agree rather than have a long fight on it and then lose it. You've wasted even more time and expense. Andrew, I think there's one that's directed at you, which has now appeared in our Q&A. So I'm just going to read it out. It's thought that the introduction of an e-filing requirement without training from HM Court Service offer further scope for filing confusion. Is it simply another set of circumstances, or may it offer greater certainty? I note that the pilot has begun, but training in September has not been repeated. So is this likely to cause further problems?
There's certainly the prospect of that. Certainly the issue in ETM was something that was resolvable because the document upload center was something that's pretty well known and pretty well used. And one of the observations of the court in that case was that the solicitor in question had used the document upload center before. I think it's something that you need, if you are a solicitor, to be alive to and be proactive about. Because if you sit on your hands and just point to problems, it may not be enough to get you over the line if there was an opportunity for you to investigate it yourself and appraise yourself of how the electronic filing works. I don't know all the details of the pilot, but certainly it's something I would have thought that in the generality of cases, and given the trend of the authorities, be proactive and don't be reactive.
And while we're on that, good law, one might think it was a bit tough because they did serve the sealed claim form on one email address and then said, oh, well, that's not good enough, so that everybody knew about it. So do you think that decision will stand the test of time?
Well, I mean, it's a really interesting point, Neil, because there was a very strong dissent in good law, which by Lord Justice Phillips, and that's effectively the point that he made. This was in his view, it was a case of if those if procedural rigor was applied in this case, it was a triumph really of form over substance, because the substance was there. There were so many ways in which the claim form had been brought to the attention of the government legal department that he thought it was a misapplication of CPR 615 to not allow service to be affected by, or to take effect as it was. Certainly that was a point that was relied upon by the claimant in ETM, but where that fell down was the court applying, I think, really the same stringent approach to prejudice, prejudice to a defendant losing a limitation defence. I certainly don't think the authorities are one way, and there's certainly going to be scope to argue for extensions of time, etc., relying upon prejudice to a claimant. And I think we'll just have to see, but it's certainly not one way in terms of the authorities. There's just salutary warnings in terms of this is the effect that may arise if you don't get your ducks in order from the very, very start.
Thank you, Andrew. And one for Charles. Well, we've still got a couple of minutes left. Charles, you gave us a really good tour of which parts of EU legislation remain in and which are out. On directives, I was following your talk quite carefully, and then I thought about the habitats regulations. So we're talking about domestic law here, have a provision that a competent authority, it's Regulation 9.3, must have regard to the requirements of the directives so far as they may be affected by the exercise of those functions. So is this a way back into the directives? I mean, how does that work?
Yes, I mean, it's a really good question, and that provision in the Habitats Directive is quite peculiar, and you don't really see it in any other context. I think a few things to note. First is that applies only to decisions being taken by competent authorities under the regulations and isn't a question of interpretation. As I said in my talk, and the recent CG Fry case establishes this principle that the directives might be relevant to the interpretation of the regulations. I think there's an open question to which version of the directive might be applicable for the purposes of the both the interpretive aspect of the common law, but also this Regulation 9.3 provision within the habitats regulations. And I can't remember if that is defined, which version of the directive is defined in the regulations. Perhaps someone in the call will be able to answer that. But it's interesting because it could actually create a sort of life for the directive beyond Brexit, whereas in other contexts, EU law a snapshot of EU law is taken before IP completion day, and you don't look at any kind of case law since then or anything like that, although it may be relevant to interpretation, and that it's unclear whether that applies in relation to Regulation 9.3, I think, but yes, it's still there. I mean, I think eventually that will go when the new habitats regime is established, on which I have no information. But it's slightly esoteric. There's nothing like it anywhere else, and it's pretty curious.
Thank you for that, and thank you to all our speakers. We've come to 12:30, so if everybody was present, I'd ask for a clap of appreciation. So we'll have a virtual clap of appreciation. Thank you very much indeed, and thank you to all of you who've joined us, and we hope you found it useful. So, bye.